And by closed hearings, I mean that the record is closed, not that the hearing is closed to the public.
Okay, Mr. Chavez, I'm sorry about that. I was two people were talking to me at the same time, but we are going to go ahead and just record it and then put it up immediately after.
Okay, that works for me.
Thank you, and I apologize for the delay this morning, everybody.
Let me know when you're ready.
We are ready, sir. Please proceed.
Great, thank you so much. Good morning, folks. We are on the record now. Today's date is February 5th, 2021. I'm Stephen Mark Chavez, the Land Use Hearing Officer for the City of Albuquerque. These are time-sensitive appeals, as you know. These are quasi-judicial administrative appeals. There's 3 of them altogether from decisions of the zoning hearing examiner. And the numbers of each of the 3 appeals are AC-20-15, AC-20-16, and AC-20-17. I've consolidated all 3 appeals together because they concern the same parties, the same facts, and essentially the same location, and essentially the same request for a variance. This is a hearing on the record, which means that it's a closed record as far as the record is concerned. That is, as far as the evidence in the record. And we are here to determine if the ZHE erred under the standards of the IDO, and I believe that's section 6-4, subsection U, subsection 4. I believe those are the correct citations. If you need to make an objection during this hearing, please raise your hand, unmute your audio on your Zoom program, not on your computer screen, which is the bottom left of the screen. And if you're not talking during this presentation, if we start having problems with audio, please mute yourself if you can. Mr. Moya might do it for you. If he does that for you, just be aware that you'll have to unmute in order to make an objection or to speak, okay? So this hearing is being recorded also by Mr. Christopher Sanchez, who is a certified court reporter, and he is transcribing the record for this appeal. The procedure of this appeal is as follows. The appellant makes an argument, and the appellant here, I believe, is Mr. Nakamura or Mr. Hernandez, or both. I see Mr. Stephen Hernandez here. Good morning, sir.
Good morning, and thank you, Mr. Chavez, for hearing us today. And I also want to thank the city and all those that are present. And yes, sure. I will be making I am the appellant. Okay, so I will be swearing you in, sir. You'll be making your opening arguments and pointing to the record. If you want to submit additional evidence, you need to do that here. I would have preferred that you would have done that earlier, but I'm very flexible with evidence. I want the city council to have as much as possible when they review this. As you know, folks, my recommendation is just that. It's a recommendation to the city council, and they are the ultimate arbiter of the IDO. So after the appellant makes his argument, I will allow the party opponents, if any, to make arguments. I am flexible on time as long as we are relevant and stay on the evidence in the case. I will allow as much time as you need. Now I will swear the parties in. Who here is testifying? I know Mr. Hernandez is testifying. Anybody else testifying in this hearing? Yeah, Mr. Hernandez, okay, let me swear you in. I see your right hand is raised. You affirm to tell the truth, only the truth, under penalty of perjury, sir? I do. Good, let's get started. Go ahead. Once again, thank you all for being our basis of understanding in accordance to the IDO 1416-64 U2. We feel that we are making this pill. We stand on the belief that the decision made by the zoning hearing examiner did not use the standard of care with respect to the rights of a student and staff for a city school, once again, a governmental
state facility, i.e. the school. All right, and the school should be allowed a safe environment, a place of learning. Moreover, we feel that the decision was made arbitrarily and capriciously and could also be referred to as a random or not necessarily to a standard of care. All right. Again, you're all.
Mr. Hernandez, let me interrupt you. The standard of care that you're referring to, I assume that you understand the standard of care is substantial evidence. That is, you have to show, let me finish. You have to show that there is insufficient evidence to meet that standard from the decision of the ZHE, or whether or not he erred in some other way with the facts, with substantial evidence. This is a record review, and so I'm not here to stand in the shoes of the ZHE and give you a second bite at the apple. I'm just here to determine if there's sufficient evidence to support the decision.
Well, and once again, I believe we have that evidence in the file and has been submitted previously.
Got it.
Moreover, if I could continue, the decision, you all have a record of that, so I won't repeat that. But we submit to you, being a school, a place of higher learning, this could be considered a special circumstance. All right, we're also filing on the special circumstance under the IDO. Okay, the subject property putting us in the same category as generally to other properties in the same zone and vicinity as outlined in the city's integrated development ordinance, section 1416-6 and 3, when it comes to a safe environment for our children in which is to learn and to be taught. We have in evidence and have cited many instances on the subject property of crime, homelessness, drug use, vagrancy, trespassing, and other social ills as a special circumstance. To the subject property, a school is typically used and is like any other, the zoning hearing examiner suggested we are like any other property in the vicinity. It is our view, at best, this is being arbitrary and capricious. Further, this decision makes mention of other schools in the immediate area, one of which is next door across the street, Longfellow Elementary. The hearing examiner uses them as an example and is comparing us to them. We should too then be given a reasonable standard of care, to wit, such as they have a safe, fenced environment for our student and our staff, just as has been given to them. Longfellow enjoys an 8-foot plus or minus fencing surrounding all of their common area. And
what does that mean?
That evidence is in the record.
What does common areas mean to you?
Well, common areas would be, and let me cite an excerpt from the state PED, because once again, we want to make sure that we understand. This is a state mandated facility run by the state public education department, the PED, state funded, state governed, a public school. Okay, we are exactly like APS. It is arbitrary and capricious to think otherwise. So once again, here's an excerpt from the state PED. And this is: with all schools shall have a safe and secure site fencing or other barriers with accommodations for safe travel.
I'm sorry, Mr. Hernandez. Mr. Hernandez, you cut off there. Can you strike that again? This is: with all schools shall have a safe and secure site.
A safe and secure site fencing or other barriers with accommodations for safe passage through openings to protect students from hazards and other nuisances and to discourage unauthorized access to the campus. This standard is met if the entire school is fenced or walled. Once again, this standard of care is pursuant to the New Mexico State PED 6.27.30.10 of the PED regulations.
That's in the record, isn't it?
It is in the record.
Okay, I thought I saw it.
Okay, and once again, we think it arbitrary to recognize this property with the land use allowing for a school and containing children housed in a learning environment to be considered and categorized as any other property in the facility. We believe that lessens the value of our children, children learning on the property, having a safe, homogeneous learning environment, same that is given to our next door neighbor, Longfellow Elementary, and for that matter, any other school in the Albuquerque district. Moreover, because of the vicinity's criminal element cited in the decision, this in and of itself should give us more cause for a special circumstance with respect to the land use assigned to this property, and certainly with regard to the standard of care for this facility housing our children. Okay, on our basis above, we are respectfully requesting a reconsideration of the denial of the variance for the 3 foot to a 3 foot maximum wall height, in this case, a wrought iron fencing for each of the case numbers that we are currently appealing.
Okay. Sir, I have a few questions for you. You didn't answer my question regarding the definition of common areas in relation to Longfellow School. You said that Longfellow has 8 foot fencing in their common areas. It's my understanding, based on the evidence in the record, that the fencing for Longfellow, the 8 foot fencing, is around the playground. It's not around the entire facility. Is that correct?
Well,
Is that correct, sir?
well, yes, but it's also correct to understand that the entire facility, as was built, is completely contained within a either fenced off area or the wall of the school. Somehow, otherwise, everything is in a sealed environment and protected through an access related type entry or an access code to get in.
So is it your position that the common areas that you described for Longfellow is the entire school facility? Because surely, let me finish,
I'm
sir.
sorry.
That's okay. Only one of us can speak at a time, or the court reporter will get mad at both of us. So it's my understanding, and again, I couldn't tell for sure. I mean, I can't go out there and inspect. That's not appropriate. I can only base my recommendation on the record in the file, and so I have to make sure that I understand that record. And it's my understanding that Longfellow has 8 foot fencing around the playground only for elementary school students. Is there 8 foot fencing around more than the playground?
Well, once again, I've not gone onto their facility. Okay, I've walked around it. I've seen their access points. I've seen that everything is within an unapproachable, if you will, and again, I relate back to the excerpt for the city, an accommodation for safe passage through openings. All right, and they're unable to get into that school playground or the facility without passing through their access related barriers. And once again, that truly discourages unauthorized access onto the campus. And that's what we are trying to.
Are you telling me you cannot answer my question regarding?
No, I'm
8-foot
sorry.
fencing?
I'm
Because
sorry,
my
that's not what I'm
question
doing.
only related to the 8-foot fencing. Again, for the third time, my question is, does the 8-foot fencing encompass the entire facility, or is it just the playground back behind the avenue there?
I believe it's the common area behind the school.
Okay.
And again, I could be corrected by Mr. Eric Bose here, who is the administrator for the school in which I represent.
Oh, okay, okay, certainly. And the reason why I asked that question again is because I couldn't tell for sure based on the photographic evidence in the record. And so I wanted to make sure.
Well, I wasn't given access to the entire facility, so I only went around the perimeter and took pictures.
Okay. And then my next question is, the charter school that you represent, is the charter school a high school? Is it for high school age students, or is it for elementary school age students?
If you will, can I let Eric Bose into the conversation, allow him to answer some of your questions?
Certainly. Well, let me finish asking questions to you, and I'll reserve that one for Mr. Bose.
Thank you.
Sure. I didn't see any evidence in the record regarding the other 3 prongs of the analysis for a variance. I only saw focus by the ZHE as well. So I'm not faulting you entirely, but under the variance request, there are 4 prongs that have to be satisfied. And I didn't see any analysis on those 4 prongs, just the first prong, which sometimes people can't make, and so they don't try. They focus on that prong as the most difficult. My concern is that the last prong is basically a mitigation kind of a prong, and that is that you have to show that this is the minimal request necessary to achieve or to mitigate the hardship, the alleged hardship. And is it your position, I assume it is, that the fencing around the entire facility at 6 foot of the charter school is the minimum necessary to achieve the protection that you're trying to obtain?
Yes, we believe that's the case. We have exhausted other revenues to include many calls to the police department, and so I would say yes.
Okay. And so just to summarize, it's your position that the ZHE erred because he was, and I know you're not an attorney, and I'm not trying to really speak in too much legalese, but it's hard not to here. It's your position that the ZHE erred because he used the conditions of crime, nuisance, vagrancy, things like that, as a general consideration rather than as a specific consideration to your request.
Yes, that is correct.
Okay. Okay, thank you. Are you finished, sir?
Yes,
I can
thank
go
you.
to Mr. Bose, and you have time for a rebuttal argument at the end if there are people that are here in opposition. Okay, Mr. Bose, are you there?
Yes, I'm here.
Okay, good morning.
Good morning.
Can you please state your full name for the record?
Yes, Eric Bose.
Okay, can you raise your right hand? Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you so much. And please state why you're here today.
Yeah, my name is Eric Bose. I'm the executive director of the school, which means I have the responsibilities of a superintendent of a school district. And so one of those things is to provide a safe and appropriate education for all of our scholars. I think that, getting back to your question of does Longfellow's fence keep in their, does it fence in the appropriate area? What we're trying to do is we're adding a second building. And so between building A and building B, we need to have some sort of safety mechanism to keep people to travel from one space to the other. At Longfellow, they are elementary school, and all of their students travel with inside the fence during the school day. So that, I think, is the distinction. At our school that we have now, we have one building inside the fencing area and one building outside of the fencing area. So we want to provide a safe avenue for our students leaving A to B, because we are a high school. They change classes periodically through the day from one building to the next without being harassed or put in a situation where they would have to defend themselves to a threat outside of, the normal school day. And so that's why we're asking for the variance to add a fence around the property, is to protect them from traveling while they are in school from one building to the next.
So you're planning to build a building in between the two A and B buildings?
No, we've only been in the second building now for a couple of weeks.
I see.
We just purchased it. And so we're now in the process of adding that building.
Oh, that building. Okay, so there's no new construction.
No, it's not absolutely new construction. It's just, we had a renovation of the property that we just purchased. And now we're trying to secure the property so the students can go back and forth between the two buildings.
Okay, so here's my concern. It seems to me that, I read the record. It seems to me that the ZHE focused on two things. He focused on the 6-foot fence being completely around the entire perimeter of both buildings. And he focused on that being distinguishable from the 8-foot fence. I mean, I'm kind of reading between the lines in the record too, because there was testimony about these things, that the 8-foot fencing at Longfellow is just around the playground. I mean, that's what it is. That's what I'm assuming based on the evidence. And that the rest of the building, especially around the frontage of Martin Luther King, has no fencing. It has other barrier type blockages, such as short perimeter walls, retaining walls, and landscaping. And I thought there was some testimony from one of the neighbors about that as being more appropriate in consideration of the request for 6-foot fencing around the front. I think that was kind of the issue to some of the neighborhood residents and the association, that they didn't want to see a 6-foot fence so close to the sidewalk. And my concern is that under the last prong of the analysis, it seems to me that that is the prong that would most speak to that issue, and that is the minimum necessary. So I'm trying to understand if the 6-foot fencing around the entire perimeter is the minimum necessary, or is it just necessary to protect the people coming into the parking lot primarily, and then maybe put a lower fence, which was recommended by a neighbor, I can't remember who, but it seems to me that that is an issue that the ZHE didn't completely resolve, and that the parties didn't completely resolve under that prong of the analysis that's required. And the reason why I'm concerned with it, Mr. Bose and Mr. Hernandez, is because, this isn't a second bite at the apple. I don't stand in the shoes of the ZHE. What I do is I review whether or not he erred under the law. And it's a very difficult standard to meet, and it's set up that way on purpose. But I can tell you that I've judged a number, probably 30 variance requests, maybe 50 in the last 16 years from various ZHEs, zoning hearing examiners, on this standard. The standard has actually been in the city ordinances for quite some time. And general crime is attributable to the entire area. And so that is why this section was written, actually. It's one of the reasons why it was written, in my estimation of reviewing the history of this, is that we can't use conditions that are attributable to the entire area to say these are special circumstances, or else the exception swallows the rule, and then everybody gets a variance if we say crime is the issue. And so I think the ZHE was trying to narrow it down, and I'm trying to narrow it down as well. And I'm hoping you folks can help me do that. Does that make sense? Yes, sir.
Yeah, if I could address that point, I think the difference that didn't come up in the first hearing was the fact that the properties served the same purpose, but the properties weren't designed the same. You know, I mean, with the changing laws and adding of charter schools, we've had to not necessarily be able to plan from the bottom up like a school district would. And so we're having to adapt to a space. And the way that the building is laid out and the parking lots are laid out, the only way to really create a safe environment at our school is to put the fencing on the perimeter. Longfellow, when they developed, and actually, I'm not sure when they put that new fencing in, the 8-foot fencing, but that was an after fact, and in a response to the neighborhood and protecting the students. And if you look at if you look at a satellite photo, the outside wall of the school serves as the barrier on 3 sides.
And which page of the record are you referring to?
I don't have the record in front of me.
Okay. I have the record in front of me, Mr. Bose. It's page 52. There is a Google satellite view that shows both schools, the entire facility of the charter school, but then and about 80% of the adjacent Longfellow school. So I'm looking at that, if that's helpful.
Okay, yeah. And so if you look at that photo, once the students get into the building, they're enclosed on all 4 sides by either a wall or fencing.
And you're talking about Longfellow.
At Longfellow, yeah.
Okay.
But if you look at our school, we have exterior doors on the new building on all 4 sides that goes into classrooms from all 4 sides of the building. And so in order to protect the students once they get on campus, I can't use the exterior walls like Longfellow does as a barrier. I have to create a fencing beyond that so they can travel inside that space, so they can go from one building to the next and from one classroom to the next. And so I think that's the point in the zoning hearing, that, you know, we're kind of comparing apples to oranges. You know, we're still in the fruit category, but we're not in the same species. So we need to be able to figure out how can we work within the zoning rules and these variances to protect our students. You know, Longfellow did the same thing. They worked within zoning, they had the space, they did what they had to do. If you look at other examples of other schools around the city, a lot of them have fencing right on the line because that's what is appropriate for them. And that's what's appropriate for us.
Okay. So is there any, Mr. Bose, and I ask this because I'm encouraging some sort of resolution, and I'd like to hear from other, if there's anybody else here. There may not be anybody else here. Mr. Fry, are you here for a neighborhood association or for acting as a neighbor?
No, I'm here for the school.
Okay, so it looks like there's nobody here from the other side. Okay.
Yeah, there is one person here.
Oh, there is. Okay.
Yeah.
He's walking down the street.
I'm walking down the street, walking to a meeting.
Okay. I'm going to give you an opportunity in just a moment. Your name is Mr. Espinosa, correct?
That is correct.
Okay. You're going to have to stop walking at some point in time. Can you do that?
No problem. Yeah,
Okay.
you just tell me when.
Okay. Mr. Bose, is there anything else you would like to add to the record?
I think the only thing that we need to add to the record is that we're actually adding in a smaller daycare as well. And so we're going to have younger kids on campus as well. So it's not just high school students anymore. We're a dropout recovery program.
Right.
And so we're going to have students who have their own kids, and they're going to be bringing them on center too. So not only be bring about their safety, but they'll be bringing about the safety of their own children as well.
Of course. Okay, I understand. Thank you so much. And I'll allow you folks some rebuttal time as well after Mr. Espinosa speaks. Mr. Espinosa, can you raise your right hand? Okay. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury, sir?
I do.
Okay, go ahead.
Yeah, so I own the 2 houses directly just to the new building that was recently purchased, the old Brooks Photo. The 2 houses directly to the north, and then from the old campus directly to the west. So my properties are literally attached to the properties of the school. And I'm speaking on behalf of myself just to let the Lujo know that our neighborhood association president recently suddenly passed away of an aneurysm. So we're kind of in flux from the neighborhood. So I don't think that there's anybody here that was that knew about this besides myself. Anyway, aside from that, the neighborhood doesn't have a problem with the school. We have Longfellow, everything like that. The main issue has been the aesthetics of the fence. And that has been the issue. The last meeting that we had with the president before he passed of the neighborhood association, and I was present, was pretty productive. There was some talks that we had for options, ideas to see what maybe could be done as far as improving the aesthetics of the fence. The main issue with the neighborhood was having was the fence that was being proposed was just a 6-foot wrought iron fence that looked very industrial and some people said kind of prison-like, something like that. It wasn't that bad, but you get the gist of it. So anyway, I think the neighborhood, I'm not speaking on behalf of the neighborhood, but I'm speaking as a neighbor and part of the neighborhood. I think the main issue from the neighborhood was we would be open to something if we could come to some compromise on the aesthetics of the fence. It's a historic neighborhood.
Mr. Espinosa, of the
Yes.
entire fencing around the entire perimeter, or just the fencing? That is, you would like to come to some agreement on the fencing in the front that faces Martin Luther King. I'm trying to narrow it down here.
So Martin Luther King and Edith. So the fence would start from the end of my property line, which as the first house is 413 Edith, and then it goes south to Martin Luther King. So it's just the frontage of the new building that was recently purchased, and then down Martin Luther King. Particularly at the corner from where the neighborhood was kind of most interested in the aesthetics. In front of the building, there's the trees, and we had talked about, depending on where the fence was placed, the trees are nice. It kind of hides the fencing over there. So the main issue was on the corner of Edith and Martin Luther King.
Okay. Thank you so much, Mr. Espinosa. You are subject to cross-examination. Do you have any questions for Mr. Espinosa? Mr. Hernandez? Mr. Hernandez?
Actually, I do. In those conversations, in those meetings that we had several of, and thank you for being here, Mr. Espinosa.
Sure.
We discussed some options on some fence heights. We agreed to that, and further, we also suggested that we would happily put on some of the Martinez Town emblems. We thought, that was possibly a compromise as well to try to break that up.
Mr. Hernandez, let me stop you there. This is not to really make an argument. This is the opportunity that you have to ask questions of Mr. Hernandez based on Mr. Espinosa based on his testimony. So just questions.
Would you agree or not, Mr. Espinosa, that the fence that we are suggesting that we would put up is typical, or for better words, exactly like what is already in place on the other building?
On the one that's in the alley?
The alley fencing and the fencing that is primarily around or in place currently on the first facility. What I'm asking, we weren't going to change that style. We were going to use the same. Is that correct?
That was my understanding, correct. And that's where the objection was from the neighborhood. The fencing that was currently there is in the alleyway, and it's recessed and nobody can really see it at all. So, we understood. It's in the back of an alleyway. And we understand, fences sometimes are necessary. So, but yes, that's what the objection was.
Very good. Thank you.
Are you finished, Mr. Hernandez?
Yes.
Okay, and I shouldn't have been so presumptuous. Mr. Espinoza, I know you're walking and probably have somewhere to go, but you can ask questions of the applicants, the appellants in this case. Do you have any questions for Mr. Hernandez based on the testimony that he's given?
Sure. And again, the information might have been
question. This would be just a question for him.
Sure.
Okay.
And again, I'm just prefacing it with the ideas or maybe compromise could have been sent to the late president, but I never saw them. Was any additional options or ideas ever sent back to the homeowners association for an alternative or maybe a compromise? I didn't see any. So did that happen? And if not, that's kind of where we had left it. So were those sent to Mr. Martinez or to the homeowners association?
No, they were not. The discussions that we had on the ground there were subject to, once again, the excerpt that I read from the state PED, what the minimum standard was. However, we did agree that day that we would consider something and more discussion should it be necessary.
Mr. Espinoza, any more questions for Mr. Hernandez only?
Nope, not at this time. If possible, depending on what happens today, I mean, it would be nice. I think the neighborhood is willing to work, and if that happens, we would welcome that.
Mr. Hernandez, do you have any questions for Mr. Bose?
No, I do not.
No, I apologize. I'm getting the names confused here. Mr. Espinoza, do you have any questions for Mr. Bose?
No, he and Mr. Hernandez, I believe, we were all together in the 2 times that I met with them. So same questions apply. So
okay, thank you. I have a question for either Mr. Bose or Mr. Hernandez. Mr. Hernandez, you indicated that this is a state facility. Does the state own the property, or are you leasing it from the state, or are you leasing it from a private owner?
I will allow Mr. Bose to answer that question. I would, however, answer that once again, the amount of dollars given by the state to the school is part and parcel to the reason why they need to retrofit a building rather than build from the ground up.
Okay, my question is very specific. I'm trying to understand. I mean, essentially, I'm trying to determine if the state owns this property or is leasing the property, or are you folks a nonprofit? Maybe that's the first question I have. Are you a nonprofit?
We are not a nonprofit. We are a governmental entity. We are a public school. We are funded through the state equalization guarantee, just like every other school around the city. So we are in a lease purchase agreement with Steve Nakamura.
I see it. He's the private landowner.
Yes.
Got it. Okay. So there are some issues that I may need to work out on the state, because if the state owns this property in some respect, or is claiming ownership of this property, there might be a preemption issue that I would need to resolve. And I wish that was cleared up in the record. It's not in the record at all. And I need to determine whether or not, to what extent the state owns this property. Can you elaborate a little bit on that?
I can definitely try to, or I can have my business manager, which is Sean Fry, speak to that. He's got the more of the technical side of that.
Okay, Mr. Fry? Good morning, sir.
Yes, sir. Good morning.
Can you please raise your right hand? Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Wonderful. Thank you so much. So did you understand my question?
Yes, I do. And so I think that the confusion comes in the fact that our charter school, so we're a governmental entity in the fact that we're authorized and controlled by APS, but we have our own local board. As far as from a determination standpoint, once we're in a lease purchase agreement, which was approved by the Public Schools Facilities Authority, as well as New Mexico Public Education Department, our building is now considered a public building, making it a government-owned building, and also, to further on to this, exempt from property taxes. So all of those notions, I hopefully answer your question. So when it comes down to who owns the building, currently the Albuquerque Charter Academy owns the building as far as the state is concerned, because we have a lease purchase agreement with the private of Mr. Nakamura.
So the ownership of the building, if the lease purchase agreement is fulfilled, will be the charter school.
Will be the charter school, yes. And if something were to happen to the charter school, then the assets fall to the state of New Mexico.
Okay.
So it falls to the Public Education Department.
So the school acts, essentially the property acts as collateral for the funding, or is it more specific than that?
I'm not sure I understand your question. Can you clarify for me, please?
Okay, so the state doesn't own the property, and will not own the property at any point in time.
The state will own the property if something happens to the Albuquerque Charter Academy. So we're basically just like Longfellow Elementary, except the fact that we have a separate charter. So we are a school within Albuquerque Public Schools. And if something happens to us, then our assets, instead of going to Albuquerque Public Schools, because that they have our charter, will go to the state of New Mexico.
Okay. So for example, a bankruptcy or some sort of trust. Okay.
Correct.
I see. Okay, so that it doesn't appear to be a preemption issue in this matter. Oh boy. So okay, thank you so much. Is there anything else you would like to add to your testimony, Mr. Fry?
No, I believe that we already addressed everything. Again, it's just the fact that we are a unique entity in the fact that charter schools, our funding is a little bit different than, say, APS. Of course, APS has multiple sites and is funded for larger infrastructure. So, we kind of have to work with what we have, which is why we built out the building. And now we're just trying to secure the environment. So I believe that everyone has already addressed those points.
Okay, thank you so much. Mr. Espinosa, do you have any questions for Mr. Fry? You have to unmute, sir.
Press the wrong button. No, but it is my understanding that Dr. Nakamura still owns the current building that is the corner of Edith and Martin Luther King, correct?
Mr. Fry, can you answer that?
So Mr. Nakamura, so again, this is where the legal side comes into play. Mr. Nakamura bought the building, but now we have a legal lease to purchase agreement that's been approved through the state of New Mexico. So it is a public facility and all of our payments go towards the principal for us to have full ownership and final ownership of the building. So it depends on what criteria you're evaluating that. So from a standpoint of legislature and access to restricted funding, that's only for a public school facility, we have that with our lease purchase agreement. As far as the name that is going to be on the building registered with the city, that again is going to be the Albuquerque Charter Academy.
Mr. Espinosa, did that answer your question? Mr. Espinosa?
I apologize. There was a loud vehicle driving by. Okay, I understand.
Okay, thank you so much. Any more questions for Mr. Fry?
No.
Thank you. Okay. Mr. Hernandez, rebuttal?
Once again, I think we need to understand several things, and I really talk about the amount of money that it requires for a school and its infrastructure, whereas a charter school has got a less bucket of that money to be able to do what they do. Therefore, once again, the retrofitting of the closest building made sense to us all. And once again, it's our position that we just want to have a secure environment for the students to go back and forth.
Okay, thank you so much. Ms. Quintana Patton, are you there?
Yes, good morning, I'm here.
Good, Patton Quintana, I apologize. Good morning. Do you have, would you like to make the record for the city planning department?
Please, I just want to, it's actually a suggestion. While the ZHE determined that there were not special circumstances that don't apply to other properties in the vicinity.
Before I let you do that, Ms. Quintana, can I swear you in first?
My right hand is up.
Okay. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
Yes, sir, I do.
Thank you so much. Go ahead.
Okay. While the ZHE determined that there weren't special circumstances that do not apply to other properties in the vicinity, I understand that application can be made to the zoning enforcement officer, the ZEO, for security reasons due to the nature of the land use. That's in the most recent amended IDO.
Okay, so you're talking about the November 2020 version of the IDO, correct?
Yes.
Okay. Yeah, that would be inapplicable here, but I think what you're suggesting is that be done after this matter is dispensed with.
I'm offering that information as a possible option.
Okay. Okay, thank you. And what section are you referring to in the most recent IDO?
It's in section 5.
I'll find
I
it.
believe it's 57D3F.
Okay. Yeah, and folks, just to let you know, what Ms. Patton Quintana is referencing is inapplicable to this application because of rules and laws requiring us to not deal with retroactive application of ordinances. That's unmistakably clear. It's difficult, but it's my position that the request is a valid request because of the issues that you're confronted with. My concern, though, is that it does not meet the standard under the variance criteria. And for me to reverse the ZHE on that standard would be to reverse 50 other cases dealing with this issue because so I'm trying to find a middle ground. I was hoping we would find some middle ground. It looks like we might have a middle ground to follow. I'm going to look at this very closely, and I'm going to make a recommendation to the City Council based on that. Hopefully, I will be thorough enough for the City Council and thorough enough for you folks to find a way to move forward. So having said that, Ms. Quintana, is there anything else you would like to add?
No, sir, thank you.
Okay, thank you. Is there anything else, Mr. Hernandez, that you would like to follow up with? Do you have any questions for Ms. Quintana? You can cross-examine her if you like, but just questions, sir.
Can I get your phone number, Mrs. Quintana, to follow up with what your suggestion is, please?
Ms. Quintana?
She's muted.
Oh, pardon me, I was muted. It's 924, and I'm sorry, but I have to look up my phone number.
It's okay.
You can also call the planning department, and they can I'm sure refer you to Ms. Patton Quintana.
Yes, thank you. Please call.
Yes. Are there any other questions, Mr. Hernandez, for Ms. Quintana?
No, but I do want to thank her for her suggestions.
Good,
My
good.
pleasure.
Okay. So folks, normally I don't answer questions, but do you have any questions of me? Because I know I've been kind of vague. I like to ponder the record before I put together a recommendation. I usually mull it over in my mind for about 4 days before I start drafting a recommendation to the City Council. And that's why I was querying you on so many issues. But if you have questions for me, I can try and answer them. I can tell you if I can answer them. First, starting with Mr. Hernandez.
I'd ask you to give us a little bit more clarity on your question with respect to the state-owned facility, because if I understood the testimony correctly, the facility will be state-owned. It's certainly state-funded, and right now it's just the ownership is lease purchase. Therefore, we're just trying to turn over every rock possible.
Of
And I
course.
thank you for hearing us.
Well, I can answer that question partly, but because I'm not an attorney that represents you folks, I don't want to go into too much depth with that answer. There are exceptions to zoning under state law and under the IDO. Those exceptions would allow, to some extent, state properties, certainly federal properties to some extent, federal properties for sure, to some extent, state properties under certain situations to preempt, that is, state law preempts zoning to some extent. And I'm saying to some extent to give myself some flexibility because I haven't reviewed those laws in a long time, but there has to be clear indication that the property is either in state hands or in federal hands to have that, to meet that exception. I don't know if we've heard that today. I don't know if I have enough information to judge that today. But you know, I'll look at that as closely as I can based on what I did here today. Okay.
Thank
Hope
you.
that answers your question, Mr.
It
Knight.
does, and thank you.
Okay. Mr. Bose, do you have any questions?
I would just have one question, kind of a follow-up to Steve's question. So would Longfellow Elementary School there, would that be in state hands?
Yeah, I can't answer that question. I'm not their attorney. I'm not the city's attorney. But that's something you should follow up with counsel if necessary. I don't know the answer to that question.
Pardon me, Mr. Chavez?
Yes.
This is Lorena Pan-Quintana speaking. When I looked up the ownership, Longfellow is owned by the Board of Education.
Okay.
And thank you.
Yeah, they're a municipal governmental entity. I'm assuming so. Just being a governmental entity doesn't exempt anybody from zoning. There has to be other criteria that's met. So, okay, thank you. Mr. Bose, any more questions?
No, thank you.
Okay, thank you, folks. Let's go off the record. I have 15 days to draft a recommendation. I will send it to all of you. Mr. Bose, I don't know if I have your email address. Is it in the record?
I am not sure.
Would you be comfortable giving it to me now?
Absolutely.
Okay, go ahead.
ERIK.
ERIK. Okay, Eric.
.BOSE
Okay.
at abqca.org.
CA.
Yep. ABQ Charter Academy. So ABQCA.
.org. Okay. And I've got Mr. Hernandez's email address. Mr. Fry, did you want me to send this to you simultaneously as well?
I can receive it from Mr. Bose. That's fine.
Good,
Thank
good.
you,
good.
though.
Mr. Espinosa, I don't have your email address. Are you there still?
I'm here. Can you hear me?
Yes. Can you give me your email address? Do you feel comfortable with that?
Sure.
Go
Sure,
ahead.
no problem. It's my first and my last name, LEON ESPINOZA 888 at yahoo.com.
Okay, so as I said, I'll get this out within 15 days and I will send it to the party simultaneously. Don't respond back to me other than to state that you've received it. The record is closed and I don't like to communicate with parties outside of that, okay? Thank you, folks. I appreciate your time. Have a great day.
Everybody.
Go off
Thank
the
you,
record.
sir. Thank you, sir.
Thank you.
Bye-bye.
Thank you all.